When we talk about landlord-tenant issues, always a good place to start with landlord-tenant issues are leases. And it's a subject that loops around endlessly in landlord-tenant cases, because if leases stink, which they often do, it causes all sorts of problems later on in the enforcement of leases, and it causes all sorts of problems in people understanding what their responsibilities were in the first place. What I tell my clients and people who come to my monthly workshops is that you need to take the time to do a proper lease that solves a plenitude of issues and does so in plain English, so that you avoid having to be in front of the man or woman in the black robe, or paying attorneys such as myself to sort out the mess. People make all sorts of crazy stuff in leases. They think a lot of Latin and crazy words and, things that they don't understand make leases more important or more valid. I look at them and I often scratch my head and go, what were these people trying to say? None of that is helpful. What's helpful are clearly delineated responsibilities that everybody understands, and language that anticipates the moment in time when you might start having trouble. So that, for instance, if your lease has things like grace periods, that you can pay the rent 5 days late, or periods of time where late charges apply and they start 7 days later, and the language is murky as to when the rent was due in the first place, whether it was due when the rent was originally said to be due or when the late charges apply. Those kind of sloppy drafting problems make the collection later on far more difficult.